Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series detailing testing the waters when conducting an offering using Form S-1. The waiting or pre-effective period is that time frame between the filing of a registration statement and the effective date of that registration statement. As with all periods in the offering process, communications with potential investors are strictly limited and regulated during this period. Also, as with other offering periods, many exemptions and safe harbors exist to allow for communications during the pre-effective waiting period. The pre-effective period is the period during which, among other things, the company begins marketing the offering through real-time oral offers, including calls to potential investors. The oral offers need not be accompanied by any documentation or a copy of the filed S-1, but are subject to the anti-fraud provisions under the securities laws. Section 5B1 of the Securities Act prohibits written offers other than by means of a prospectus that meets the requirements of Section 10 of the Securities Act. And S-1 meets such requirements, and so any written offers would need to be accompanied by the filed preliminary S-1. Such bans on communications are designed to prohibit inappropriate marketing, conditioning, or hyping of the security before all investors have access to publicly available information about the company so that they can make informed investment decisions. Other than a free-writing prospectus for qualified companies and test the waters communications by an emerging growth company satisfying the requirements of Section 5D of the Securities Act, which is the implementation of Rule 105C of the Jobs Act, the only written offer materials that may be distributed by the company during this period is the preliminary prospectus, which must satisfy specified SEC requirements. Rule 105 is the same during the pre-effective period as it is for the pre-filing period. I will give a reminder on those provisions as well as details on free-writing prospectus and communications that are not deemed an offer in future Lawcasts in this series. While binding commitments cannot be made during this period, the underwriters will receive indications of interest from potential purchasers, including as to the price they would be willing to pay and the number of shares they would be willing to purchase. Also during this period, key management personnel generally will make a series of presentations covering the company's business and industry, market opportunities, and financial matters to the investment community. The underwriters will use these presentations as an opportunity to ask questions and establish their due diligence. This presentation period is commonly referred to as the roadshow and generally is conducted in the 2 to 3 week period immediately prior to the effectiveness of the registration statement and ability to complete actual sales of securities. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.